So good morning, everyone. My name is Dan Schofield. I'm a litigator with SFG Paralegal Services located in Richmond Hill. This is our Human Rights in the Residential Leasing Process seminar that we provide. We provide it to many realtors and landlords several times a year, and we really appreciate you joining us today. So what we're going to discuss today is what's the Human Rights Code, what does it say, what's a legal test. We're going to deal with some frequently seen questions that our office gets. We're going to talk about discriminatory rental ads. We're going to talk about possible discrimination on rental applications. We're going to talk about discriminatory rental criteria. We're going to talk about grounds for refusal to rent. We're going to talk about behavior once a person is a tenant very, very briefly. We're going to, the points that are mentioned in this presentation is by no means an exhaustive list. If you're unsure, then you should consult a legal representative before communicating with any further applicant tenant. And this presentation only applies to tenancies that are protected under the Residential Tenancies Act. This presentation seems to evoke very strong reactions when we're going through it. The main takeaway from this presentation should be that you need to keep all of your records when you list a place for rent for at least 1 year. And the purpose of that is to prove that you did not engage in any form of discrimination when you leased your unit. And it's also to protect yourself because the Human Rights Tribunal has a 1-year statute of limitations. So nothing in this presentation today should be seen as legal advice. This presentation does not create a client relationship. If you require assistance, you can find resources at the Human Rights Legal Support Center or at the Law Society of Ontario's referral service for a licensee. We're not able to provide specific legal advice during this presentation. So I would ask that when you do ask your questions, you frame them in a way as not to give us specifics about your situation, but rather ask the question generally so that we're able to answer it for you. So what is the Human Rights Code and what does it say? So the Human Rights Code is the law of Ontario. It gives all people equal rights and opportunities without discrimination in specific areas. The area that we're going to be dealing with today is accommodation. The code prohibits discrimination on harassment based on race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, marital status, family status, disability or the receipt of public assistance. The Human Rights Code is what we call a quasi-constitutional piece of legislation. It means it's second only to the Constitution of Canada. It overrides every other act or statute, at least in the province of Ontario, because the Human Rights Code is an Ontario piece of legislation. It also protects people in regards to services, contracts, people under 18, employment, vocational associations, sexual harassment or reprisal, but we're not going to be discussing any of that today. We're only going to be dealing with housing. So during this presentation, you are going to hear me talk about the term undue hardship. Undue hardship is one of those legal terms that is not actually defined anywhere in the statute. So it is very much a case-by-case basis, but landlords are expected to accommodate all people, whether they be prospective tenants or tenants, to the point of undue hardship. The three considerations for undue hardship are cost, outside source of funding, or any health and safety requirements. Nothing else is considered. So we can get into undue hardship in several situations later on, but those are the three main factors when considering it. So what we're going to do is we're kind of going to go through the whole process. So we're going to go from the ad itself to the application phase to the meeting in person phase, and then very, very briefly deal with a situation once a person becomes a tenant. Now, I updated this presentation yesterday. So anybody who's seen it before because I think there are a couple of people who've seen this presentation before, will notice that the ad has changed. So this is an ad that I pulled off realtor.ca yesterday for information purposes. This was the first ad that I clicked on. I did not need to go searching for this. I simply just went to the ad, clicked it, and there was that. And the ad reads fairly normal until the last couple sentences where it says looking for AAA tenants, rental app, an employment letter, credit check, and a $300 key and cleaning deposit. The cleaning deposit's not legal under the RTA, but that's what we're discussing today. So I want you to look at AAA tenants, rental app, employment letter, credit check while we're doing this presentation. So when listing rental opportunities, landlords cannot exclude identified people identified by code grounds. For example, phrases in rental advertisement, such as suits a working person, it may indicate that people who receive social assistance or are unable to work due to a disability or other code ground are not welcome or need not apply. Other forms of advertising that are inappropriate would be adults only, adult lifestyle, not suitable for children, suitable for single person or couple, working people only, professionals only. Understand that with the Human Rights Tribunal, it's not enough that it's not required that that person actually apply for your unit and be turned down in order to file a human rights complaint against you. They only need to be able to prove that your rental advertisement was worded in such a way where they felt that they were not able to apply based on the fact that they were protected under a code ground. So if somebody who was on CPP or OAS saw the word employment letter and as a result of employment letter didn't apply, they could still file a human rights tribunal case against you and just simply say that the requirement for an employment letter was enough to make them feel like they were being discriminated against based on the fact that they were on CPP and OAS. Discriminatory advertising that targets households with children may be more subtle, where landlords is attempting to discourage or deny applications from families with children. They may use euphemisms like a quiet building, not soundproofed, geared to young professionals. When using statements above, if coupled with a refusal to rent to a family with children, it may indicate discriminatory attitudes related to family status. And Section 13 of the code actually prohibits publication or public display of any sign or emblem that would indicate any of the statements made above as well. So what they're basically saying is Section 13 would apply to this rental advertisement to the left. So because it indicates a discriminatory attitude towards a certain protected ground. So screening phone calls, I mean, obviously screening phone calls, you know, it's a part of the business. People call, talk about their ad. So what do you need to be aware of when you're screening potential tenants over the phone? So telephone inquiries, you know, when people are asking about being a prospective tenant, their name can reveal characteristics about their identity and whether or not they belong to a code ground. There have been many cases where after a telephone conversation with somebody, a landlord simply says, well, the unit's been already rented and we're not interested to hear from you anymore. The practice is referred to in case law as linguistic profiling. So any tenant screening of any kind that targets people based on a code ground contrary to human rights principles may result in a claim from the Human Rights Tribunal. Now, I'm not saying don't talk to people on the phone. I'm not saying that talking to somebody on the phone and telling them that the apartment was already rented in itself is an act of discrimination. But what I'm saying is you need to be conscious of it, because while you're on that phone call, you should be keeping notes contemporaneously to say, well, I received a call from this person at this time, their name was this, they identified the following on the call, and based on the information they provided me during the phone call, I chose not to continue speaking with that person. And we'll get into other discriminatory things that you would possibly turn them down for that you shouldn't, but it could be as simple as just saying, you know, my current landlord's evicting me and I need to find a new place. Well, you can turn somebody down for that. There's nothing discriminatory about it, but you should certainly keep notes of that phone call. So application forms. Housing providers, real estate agents, property management companies hired to find tenants often engage in practices that are designed to screen out people identified by certain code grounds. So application forms that ask for a person's source of income may reveal that the person is receiving social assistance or that a person is unemployed due to the presence of a disability. A person's name, again, while a necessary piece of information, may indicate that a prospective tenant is a member of a racialized group or a particular creed. Creed, as defined by the code, includes religion. It is not the only definition of creed, but certainly, religion would play into creed. Application forms often ask for the age of potential tenants, which has been found to be a prima facie case of discrimination. Just asking for the age itself can be discriminatory. Application forms may also be used to determine the number of children in a family. If you are a landlord and you ask for such questions, the onus will shift to you to show that those questions played no factor in your determination. So let me be clear. If you ask the question and somebody brings a human rights complaint against you, you will be required to prove that the information on the application form had nothing to do with it. And this does and can happen. I am currently representing a landlord. That landlord is one of 6 people named as a respondent on a human rights tribunal application. The grounds for the discrimination were that the tenant had been discriminated on based on race, because her name identified her as a member of a code protected ground, and the application asked for her age and the age of her 2 children. And I believe, based on the circumstances of my client, that the tenant will ultimately be, well, the prospective tenant will ultimately be unsuccessful. They have spent up to date about $4,500 plus HST defending this application. So just be aware that by asking for the information, you open yourself up to that. A landlord can ask for that information if there's a bona fide requirement, such as if it is a senior's residence, and therefore it would only go to a senior. And if they really do require, the amount of people or the type where the income is coming from, or any of that other stuff that would normally be associated with a rental, they could ask for it after their preliminary application has been approved based on just the information itself. So a potential tenant with 2 children, they wish to rent a 2-bedroom apartment. Can you refuse based on your opinion that the apartment would be too small for them? So a landlord cannot refuse to rent an apartment solely based on their opinion that it would be overcrowding. If you refuse an apartment because you would prefer 1 child per bedroom, that's considered discrimination based on family status. The exception to that would be only if it would violate local bylaws on overcrowding, and children are not normally covered in that bylaw. So if for that 2-bedroom apartment you had 6 adults wanting to apply, you would probably be able to turn them down quite confidently. But the moment you have children involved, children aren't covered under the act as overcrowding, and they're not covered under most bylaws as overcrowding. So turning them down would be a code violation, or it could be a code violation. So how do you evaluate a rental history, right? If everything seems to be discriminatory up till now, so how do you evaluate it? Well, a lack of rental history may be related to a code ground. So for example, a recent immigrant or a refugee may have a lack of Canadian rental history. A man or a woman may be attempting to reestablish themselves after a marital breakdown and may find themselves in a similar situation. So landlords are strongly encouraged not to treat the lack of a rental history as equivalent to a negative rental history. Doing so could place you in violation of a code ground. If a prospective tenant lacks a rental history for reasons related to a code ground, landlords should begin looking at other available information on the prospective tenant to make a bona fide assessment of that tenant. So if they don't have a rental history, maybe you would look at credit. Maybe you would look at family references or somebody else that might be able to give you more information on that lack of rental history. It is possible that some prospective tenants identified by code grounds may more likely have lived in rooming houses or have lived at past residences for shorter periods of time. So you do need to make that consideration when dealing with those groups of people. So some landlords place a requirement that potential tenants has a stable long-term employment. This requirement could be for people identified by several code grounds. It could be contrary to their rights. For example, a requirement for employment history can or is likely to have an adverse effect on women who've taken time out of the workforce to raise children, for caregiving of others who are otherwise, trying to establish and support themselves independently now. It could also affect new Canadians, people with disabilities, people who are unable to work, people who receive social assistance. This includes older people who are receiving benefits from CPP or OAS, seasonal workers, young people starting out, who all tend to have either shorter employment histories or no employment history. And while the code allows for a landlord to ask for income, it does not allow a landlord to ask about employment history when deciding if they should rent to a prospective tenant. So let me be clear, if you already decided to rent to that person because their income on paper shows that they can afford the unit that you're renting, there's nothing wrong with then asking them, hey, can I get, your information about where you work? As long as it didn't factor into the decision to rent to them, it is not discriminatory. However, the HRTO found that it is a violation if an applicant tenant is discriminated against due to a requirement that the application be employed on a permanent basis or satisfy a criterion asking for a minimum tenure with an employer. If a tenant is receiving social assistance or some other form of government funding, can you refuse to rent to them? I see this a lot online, where people are asking about tenants who are on CPP, OAS, ODSP, Ontario Works. So the answer is no. You can't discriminate based on the fact that they're in receipt of public funds. It's not legal to request a person receiving public assistance be subject to a request if it is not required by all potential tenants. And even if a request is required by other applicants, it could still be discriminatory. So I'll give you an example. The case is Garbutt and Fisher. It's a case that was decided in the British Columbia Human Rights Tribunal in 1996, where they found that in some cases, asking for a first and last month's rent deposit were discriminatory on certain people who relied on public assistance. Now, this is probably not relevant to 99% of the rentals that you are engaging in, but if you have a rooming house or a rental property that in effect targets lower income individuals, this is something that you need to be conscious of. Requesting a cosigner or someone to guarantee the rent can be discriminatory if it is not something that will be requested for all potential tenants in a similar financial situation, but with employment income. So an example of this would be, you have an application, the tenant says they make $3,000 a month, the rental unit is $2,500 a month, and they have decent credit and they've got good references, and you agree that you would rent to them until you find out that the $3,000 a month is a combination of ODSP and child tax credit and child support. And now all of a sudden you say, well, no, you need to have a cosigner. So that wouldn't work because you would have rented to them had they said they were employed at Canadian Tire, you would have rented to them. You only made that decision not to rent to them once you found out they were on receipt of public funds. How do you evaluate a credit report? So a landlord is permitted to request credit references and to conduct credit checks with the permission of a prospective tenant. They may consider this information selecting or refusing a tenant. A landlord should be aware that a requirement for a credit check may have an adverse effect on people identified by code grounds. Again, for example, women returning to the workforce after lengthy periods of caregiving or after the breakdown of a marriage. Young people, newcomers, for example, may have little or no credit history. The HRTO has found that the practice of refusing an application with little or no credit may have a disproportionate impact on people with code grounds. So landlords cannot evaluate a lack of credit history as being the same thing as a bad credit rating. Even with a bad credit rating, there may be extenuating circumstances relating to code grounds that should be examined before rejecting an applicant. The person should be able to explain their situation or potentially ask for accommodation. And an accommodation may be other forms of rental criteria, such as a cosigner. In all cases, a credit history may only be considered as part of a bona fide attempt to validly assess potential tenants. So if you go back to that rental listing that we had at the beginning of the presentation, they asked for a credit history right off the bat. So if you say to a tenant, I'm not going to talk to you until I've seen your credit, and I want to know nothing else about you until I've seen your credit, and then they send you a credit report and their credit report is low and you never return their phone call again, that could be, not always, but it could be a violation of their rights under the Human Rights Code, because there may be other things that are impacting their credit which are protected under code grounds, and you need to factor all that information in when making a decision. And to be clear, this is not my interpretation of the Human Rights Code. So all the information contained within this presentation is either taken from the Human Rights Code itself or is taken from the Human Rights Legal Support Center's white books and white pages on landlord's duty to accommodate and what that means. So all this information is publicly available. I've just put it together into one presentation for you. So please keep in mind when I'm providing this information to you that this isn't my opinion. This is what the law says. So what's a ground to refuse a rental unit? So again, a landlord may request credit references, rental history information, or both. They may refuse based on their results. A landlord may request income information from a prospective tenant only if the landlord has also requested a credit check and a rental history. So you can't say to somebody, tell me what you make, unless you've also requested from them a credit check and a rental history. In other words, you cannot make a determination to rent from somebody simply based on what their income is. If after requesting the information, a landlord has only provided the income information, the landlord may consider the income information alone in order to assess the prospective tenant, and the landlord may select or refuse the prospective tenant accordingly. A landlord may only use the information to determine a tenant has an income, but is not allowed to judge the source of the income. And a landlord cannot use a ratio to determine a tenant's worthiness. They must only consider that a tenant receives an amount sufficient to pay the rent and cannot consider what their non-housing expenses should be. And this was established in Shelter Corps in Ontario. So why is this important? So we often see people saying, well, I don't want my tenant to spend more than 30% of their income on rent or 40% of their income on rent. And the HRTO has said that that's a prima facie case of discrimination, and that if the rental unit is $3,000 a month and the tenant proves sufficient income to cover $3,000 a month, a landlord is not allowed to now impute whether or not the tenant can afford that. Now, a lot of this can be for various reasons. Some of it would be that maybe that tenant has off the book income that they don't declare. Maybe that tenant is receiving child support or child tax credit or HST rebates that allow them to sustain themselves above and beyond what the rent is. But a landlord cannot assess simply based on a ratio whether or not that tenant can be taken into a unit. A landlord can ask for a guarantor, and a landlord may refuse a tenant who owns an animal if that animal is not a service animal. I would suggest, this is my own opinion, but I would suggest that if a prospective tenant puts down on their application that they have an animal, that it would invoke a duty in the landlord or landlord's representative to inquire as to whether it is a service animal or not, so that if it was a service animal, you don't inadvertently discriminate. And when I talk, there's a lot of talk about guarantors and them only being available if you would ask for any other prospective tenant. Well, if you have somebody who presents a credit score in the low 500s, with little or no history or bad history, and they're making just enough to cover the rent, I would suggest that that's no longer an income ratio issue. That's just whether you're making a determination based on all the information that's available to you, whether that prospective tenant is going to be the right person for your property. And it would probably be completely appropriate to ask for a guarantor. Now, if that prospective tenant had a above average credit score, money in the bank, but they were receiving, some other type of assistance, and that amount only amounted to the rent and how much the rent is every month, that you have to probably take a deeper dive. And you may want to actually consider speaking to a representative who's licensed by the Law Society, who's well-versed in human rights law, to try and figure out what your next steps would be with that particular tenant. So if a tenant is new to Canada and they have no credit history, can they be asked for a deposit? We see this a lot. Realtors, landlords, watch out. The absence of credit and previous landlord references is not the same as bad credit and bad landlord references. It is legal to ask for a cosigner or someone to guarantee the rent in certain circumstances. But if you ask that person to provide you an above normal deposit based simply on the fact that the person is a refugee or a recent immigrant, it is very much a human rights complaint. And I would argue a successful human rights complaint. So you have to be very, very careful. And this is not about whether the act says that you can get the deposit if the tenant consents. A person may consent to something because they want to live somewhere. It doesn't absolve the person who took that money of the possible human rights guarantee, of the possible human rights issue that arises from it. So again, cosigners, guarantors, they may be appropriate for poor references, poor credit history, history of default. They're not allowed to require guarantors simply because the prospective tenant is a member of a code ground, such as being a lone parent, a newcomer to Canada, a youth. I don't know if everybody remembers, but about 3 years ago, a young couple tried to rent a building, an apartment in a building in Toronto, and they were turned down because of their age, and they were unwilling to provide a cosigner. The Human Rights Tribunal hasn't decided the case yet because it takes them something like 4 or 5 years to dispose of a case in their normal course. But I would suggest that that was certainly an act of discrimination. A landlord who requests a cosigner or guarantor cannot impose conditions on the cosigner or guarantor that they would not require of the tenant. So they can't now impose an income ratio on the guarantor. They can't impose deposits on the guarantor. They can't impose anything on the guarantor that they would otherwise not be able to impose on the prospective tenant. Security deposits we already talked about, so I'm not going to talk about that again. So now you've gone through the advertisement, phone call, application process, and now you're at the in-person meeting process. And sometimes tenants and landlords will find that once they meet somebody in person, the unit becomes unavailable. Now, in a lot of those cases, it may be difficult to prove discrimination. I'm going to argue that it's not that difficult now with text messages and emails and other such things. In fact, there was a Human Rights Tribunal decision where a prospective tenant had been communicating with the landlord, went to go see the unit. When the landlord discovered that the person meeting him was African American and pregnant, the unit became unavailable almost immediately. And based on the text messages exchange and the email exchange between the landlord and the prospective tenant, the Human Rights Tribunal awarded that tenant about $15,000 in damages because it became very obvious that it was a code ground. When a housing provider receives multiple tenant applications, you need to be prepared to show how you chose the successful applicant. So for instance, maybe the successful applicant was the first person to apply for the unit and it had none of the other factors played a role in your decision. You need to be able to show that. And as I said at the beginning of this presentation, you want to keep all of that information for at least 12 months, because that is when the statute of limitation runs out for the person to file a human rights complaint. And just as an example of that, I spoke to you about the case where I'm representing one of 6 respondents. In that particular case, the applicant had waited until the 11th month to file the application. My opinion of that is that they waited to the 11th month because they were hoping that any records in regards to that claim had long been discarded and were no longer available. My client, however, did keep everything. And that's why I think that this person will be ultimately unsuccessful, because of that communication. But that just illustrates to you how important it is for that communication to be kept. So tenants' rights in relation to the HRTO. When renting, discrimination is not just found in the application process. Tenants may experience equal treatment once they become a tenant. I am going to deal with this simply by saying, as a landlord or as a property manager, you have an obligation to ensure that your tenants are not discriminated against based on code grounds, even if they are being discriminated against by other tenants. If you do not bring applications at the landlord tenant board to terminate a tenant who is making discriminatory comments, you could also find yourself at the Human Rights Tribunal having to be responsible for that behavior and not having addressed that behavior. And that's how I'm going to address that slide, not much beyond that. And that's what I spoke to about here in this slide as well, where I'm simply saying that you have an obligation to protect your tenants from discrimination. So that is the end of the presentation portion of this presentation. I'm going to stop sharing my screen now. I'm going to turn my camera on, and I'm going to stop the recording and allow for questions.